there are four basic types of evidence. So we've already discussed the witnesses, laying expert witnesses, and the exhibits and the three different types of exhibits. The third type of evidence is stipulated facts or stipulation. So either term is appropriate. And this is just an agreement between the attorneys. And so this can be a written stipulation where they both sign off on. It could also occur under a request for admissions, which we're going to be talking about next semester. But it is a way to sometimes expedite certain information instead of having another witness testify to certain facts. If the parties already agree, then they don't have to go over them. So don't see those a huge amount in practice, but it is a type of evidence. And then the fourth type of evidence is judicial notice. And this is where the court will accept information as fact without requiring further proof. So usually it's facts that are either commonly known or easily ascertainable. And so the example that is in the PowerPoint is my example. I was representing a tenant who was trying to get money back from his landlord, and he was an excellent client because before he even came to see us, he had done everything right. So he had given his landlord the appropriate written notice, and he had sent it by certified mail. So when he went to try to get a security deposit back, the landlord was refusing. But we had the documentation of what he did and that he followed all the steps per the lease that the landlord made him sign. So we go into court and the landlord says, well, I'm not going to accept a certified letter. I don't know who that is from. And my client, of course, had sent the certified letter with the appropriate notice. So once the landlord denied that she knew who the letter was from, I pointed out to the court that the nature of certified mail requires a return address on it, and that the post office will not accept it without the return address because they need the address to send the green card back to. And so the judge at that point said, I take judicial notice of how certified mail works. And so that kind of killed the landlord's argument right there, which was good news for my client because he did get all of his money back. But anytime you're talking about very common facts that people otherwise know or that are so easily ascertainable. If the judge didn't take judicial notice of certified mail and the process for certified mail, it didn't mean that we couldn't offer that as evidence, but it meant we would have to bring somebody in for the post office to testify to it. So it doesn't, anytime where judicial notice is not taken, you can still offer the evidence. You just might have to go a little more roundabout way of doing it. So those are the four different types of evidence: the witnesses, the exhibits, stipulated facts, and judicial notice. So that is what is evidence. So what is not evidence? So what we say at trial. So what the attorney says at trial, what we say, not evidence at all. Our goal is to ask the questions, to elicit the testimony, and the testimony itself is the evidence. Or to offer an exhibit into court, and the exhibit itself is the evidence. But what we say is not evidence. Our opening argument is letting the jury know what the case is about, giving them the opportunity to get to know our client, telling them what evidence we will be offering. But what we say in the opening argument is not evidence. Same thing with closing argument, not evidence. We're going to summarize what they just heard. We're going to highlight the important testimony and exhibits and information that was offered into court. But what we personally say in court is not evidence. So that's kind of the big one. Second thing that is not evidence, as you already know, is any information that the judge or jury obtains outside the trial. So if it's a jury trial, it can be a huge problem if the jury considers information that was not offered in court. That actually would be grounds for a mistrial. But if you just have a bench trial where the judge is hearing the evidence and making the decision, same thing for the judge. The judge can only make the decision on what is offered in court. So any other information out there is not considered evidence and should not be part of the decision-making process. Similarly, any testimony that is stricken or excluded from the record, not evidence. And this is the one that people struggle with the most because it is the proverbial unringing of the bell. If a party or a witness has already said something in court and then the judge says that is stricken from the record, jury, you are to disregard it, they've already heard it. That's a very difficult thing to do. And that is true, but that does not mean that they are supposed to consider it. So if they were to consider it in their deliberations, if it seemed like they considered it based on their decision, that would be grounds for an appeal. But it is officially not evidence if it is stricken or excluded or not allowed, and it is on the record as such. Jury instructions, also not evidence. The jury instructions usually give guidance, but they're not offering new or different information. So for instance, a jury instruction might say something like, if you believe that defendant failed to do something, then this, but they're not telling you what the information is. They're not offering new information. They're just giving guidance to the attorney. And there are standard jury instructions. If you work for a litigator, you may find yourself drafting those, because frequently judges ask the attorneys for their draft jury instructions. It's ultimately the judge who decides what the jury gets, but this is not something you would have to create from scratch. There's plenty of things out there. So those basically are the four big categories of things that happen in and around a trial but are not considered evidence and therefore should not be considered when the decision is being made in the case. And that, again, is true whether it is a jury trial or whether it is a bench trial with a judge making the decision. Okay, so a couple of other terms that we need to go over just to make sure everybody's clear on it. And that is the distinction between direct and circumstantial evidence. So direct evidence is something the witness personally observed. So if I am a lay witness and I come in to say, I saw the car run the stoplight and hit the other car, I am a lay witness, my firsthand personal knowledge. I am offering direct evidence because it is information that I personally observed. And if the jury or whoever the trier of fact is, believes what I am saying, it establishes the fact of the case. So it is information that goes directly to supporting the case, whether it's supporting plaintiff's or defendant's side of it. So that is direct evidence. That's usually not the one that people have issues with. The one that people struggle with, because it is much more challenging to define, is the circumstantial evidence. So first, want to throw out there the just a caveat, because a lot of times, based on what we see in TV and movies, people think circumstantial evidence is bad evidence, or it is always weaker evidence. So how many times have you seen a TV show or movie and they're like, we can't bring that case to trial, it's all circumstantial. And people get this idea in their head that circumstantial evidence is bad. Circumstantial evidence can actually be good, strong evidence. And we all know that direct evidence, lay witness testimony, eyewitness testimony is frequently not so good. So you don't want to view one as being good and one as being bad. You really want to look at the quality of the evidence itself. Most cases, we're going to have a combination of direct and circumstantial evidence. And so everything's going to balance each other out. But circumstantial evidence would be a situation where we don't have a witness who saw a specific fact, but we can present enough information around that fact that allows the judge or jury to infer that it did happen. So as an example, and this was one that my criminal law professor used in law school, you have a bank robbery. We have no eyewitnesses to somebody actually being in the bank, robbing the bank. But we have witnesses who can put the suspected robbers at different locations in a time frame that makes sense to infer they robbed the bank. So you have a witness that sees the robber get in the car and drive down the street towards the bank. You have another witness that sees the driver in the same car about a block away from the bank, heading towards the bank. You have another witness who sees the driver park the car in front of the bank and get out and walk towards the bank. Then you have another witness who sees the person coming from the direction of the bank, carrying a bag, getting into the car and speeding off. Okay, nobody actually saw the driver break into the bank or actually rob the bank, but you have enough evidence around it that can lead the judge or jury to infer a particular fact. So you don't want to automatically assume circumstantial evidence is bad, that it's weak, that you can't use it. You have to look at what the evidence actually is, because in that scenario, if you have solid witness testimony, that's going to be a pretty strong case, even though you didn't actually see somebody, you didn't actually see, none of those witnesses actually saw the would-be defendant robbing the bank. So that's one thing very important to keep in mind with that distinction. So that is direct and circumstantial evidence. And I had a student one year share an example that his criminal law professor used in class. And apparently the class had, and it was at a different campus, but apparently the class had a couple students who were a little mouthy, I guess, for lack of a better word. And the criminal law professor gave the example, if everybody leaves the room but these two students and me, and I then leave the room, and the students walk back into the room and see the other two students bloodied and beaten, you didn't actually see the professor beat up the students, but you can infer it from the facts. So that's another type of example of circumstantial evidence. And the last thing I want to talk about is getting into the concept of relevancy. So in class, we're going to go through an example of relevancy, but you want to make sure you have a good definition and understanding of it. So this is Pennsylvania Rule of Evidence 401. And this is the definition there. So evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. So that is a very good definition, but it is long and I think it's hard to memorize. So that's why I default in, does it tend to prove or disprove a fact of the case? If it tends to prove or disprove a fact of the case, it's the fact is of consequence to the determination of the action. So that is couple different definitions. So what you also have to keep in mind with relevancy is there is not a line where everything on one side of the line is irrelevant and everything on the other is relevant. You have to look at relevancy as a continuum from things that are not relevant to information that is. And so there's going to be types of information that clearly will not seem relevant to you. There's going to be types of information that clearly seems relevant, but there's going to be a gray area in the middle where you could actually have a good faith dispute about whether or not information is relevant. And so again, it's just proving a fact of the case, not the ultimate decision of the case. So the example there, you have a car accident between plaintiff and defendant, and you offer evidence that defendant is late to work every morning. Is that relevant? It might be relevant if defendant runs late, if he's in a hurry, if he's rushing, that might be relevant information. It does not prove that he is in fact liable in this case, but it might be relevant to a fact of the case. And so that's what you want to keep in mind. Is it a fact of the case? Evidence that the defendant was late once before 2 weeks ago, probably not even relevant to a fact of the case. So those are the types of issues that we need to be paying attention to. So another example that we used to use a separate evidence textbook, and this came from that. Sam's car is taken by George. The only issue is whether or not Sam had given permission. Now, George's car then is seen in, Sam's car is then seen in an X-rated movie theater. And so now they're in court, and Sam's suing George for taking his car and, for damages to the car and whatever. And they want to offer into evidence that the car was seen in an X-rated movie theater. Is that relevant to whether or not George had permission to take the car? It really isn't relevant. It doesn't tend to prove or disprove a fact of the case. Did he have permission? But trying to get that information into evidence could certainly sway a jury, because then they might view George a little bit differently. So when we're dealing with relevant evidence, it has to prove or disprove a fact of the case. If it is relevant, it is admissible. There are certain exclusions, and that is where we are going to pick up next week.